civil requests have already been made, but there's two things that need to be brought up immediately. 28, Section 1350, aliens action for tort. The district courts shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States. June 25th, 1948. 646, 62 Statute 934. Under historical and statutory notes on page 824, what does it say? Section 3. Extrajudicial killing. For the purposes of this act, the term extrajudicial killing means a deliberated killing not authorized by a previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized peoples. Such term, however, does not include any such killing that, under international law, is lawfully carried out under the authority of a foreign nation. Now, if you do not succeed in your extrajudicial killing, there's still a crime. And it is under 28, Section 1350, aliens action for tort. If you refuse to acknowledge it as a criminal proceeding and insist on regarding it as if it is a civil proceeding, then what is the appropriate effort to invoke the 11th Amendment for consideration? This is one situation that needs to be addressed. But besides just this as a consideration of a response, there's the actual literal effect, which is that there is an action for a tort that can be compelled or called or requested by an alien in the district court. Insofar as that's the case, we should also review 28 Section 455, disqualification of justice, judge, or magistrate judge. A. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. B. He shall also disqualify himself in the following circumstances. 1. Where he has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding. 2. Where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. 3. Where he has served in governmental employment and in such capacity participated as counsel, advisor, or material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case in a controversy. 4. He knows that he individually or as a fiduciary, and this is the important part, as a fiduciary, or his spouse or minor child residing in his household has a financial interest in the subject matter in controversy or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. 5. He or his spouse or a person within the third degree of relationship to either them or the spouse of such a person is party to the proceeding, or an officer, director, or trustee of or a party. I is acting as a lawyer in the proceeding. I is known to be the judge to have an interest that could be substantially affected by the outcome of the proceeding. IV is, to the judge's knowledge, likely to be a material witness in the proceeding. 1, 2, 3, 4. Now, wow. C. No justice, judge, or magistrate judge shall accept from the parties to the proceeding a waiver of any ground for disqualification enumerated in subsection B. Where the ground for disqualification arises only under subsection A, waiver may be accepted provided it is preceded by a full disclosure on the record of the basis for disqualification. F. Notwithstanding the preceding provisions of this section, if any justice, judge, magistrate judge, or bankruptcy judge to whom a matter has been assigned would be disqualified after substantial judicial time has been devoted to the matter, because of the appearance or discovery after the matter was assigned to him or her, that he or she individually or as a fiduciary or his or her spouse or minor child residing in his or her household has a financial interest in a party other than an interest that could be substantially affected by the outcome. Disqualification is not required if the judge, justice, magistrate, judge, bankruptcy judge, spouse, or minor child, as the case may be, divest himself or herself of the interest that provides the grounds for the disqualification.